I seek Lordship's indulgence in mentioning part 2, item number 4, which is a fixed item.
It was a fixed item.
Yes. Item number 4. My lord, if this item may kindly be taken up next week on Tuesday, on the 3rd.
You are for the appellant or the respondent?
I am for the respondent. I have taken consent, ma'am.
You have taken consent?
Yes.
With the consent of the other side, you learned consent for the respondent, wait for an adjournment. In that case also, next week, do you want any fixed date here or next week?
On the 3rd, my lord. 3rd February.
3rd of February?
My lord. Tuesday.
3rd of February, Tuesday.
We
We were listing it on 3rd of February.
Please, Your Lordship, may I make a mention regarding part 2 of item 5? If the
Item number?
Part 2 of item number 5.
5.
If the matter may be taken 5th
It was also a fixed
February.
matter.
Huh?
It was also a fixed matter.
Yes, my lord.
You are for the appellant?
Yes, my lord.
So when do you want now?
5th of February next week.
5th of February. You are for the appellant?
Yes, my lord.
Okay, same order. Okay, by listing it on 5th of February.
Hopeless, ma'am.
For motion, item number 1.
Your Lordship, this petition is under Section 5 through 8 BNSS, read with Section 483 BNSS to relax or modify the bail condition imposed by Learned Judge of Special Court of NDNPS Act in order dated 15/9/2025 in bail application number 343 of 2025. Your Lordship, the petitioner was granted bail on 15/9/2025. However, there are some bail conditions that petitioner could not fulfill, and he is in judicial custody till date.
Now, why are you, this, obviously, there is, amount is a bit high, 5 lakhs. But you no need to deposit 5 lakhs. Is there any provision here? Because in the other states or in Assam particularly, it is a bail amount. You no need to, if you have this same land documents and all for the same to furnish the security of the land documents and all, that must be sufficient. You no need to pay in cash. Is there any provision here to pay in cash? Because 5 lakhs is there, it's okay, it's a bit higher side. But the question is that, is there any necessity to file it, submit the cash amount here?
No, my lord.
No. Then in that case, what is your difficulty? What's finding difficulty?
Our difficulty is also
Obviously,
bail.
I do agree that 5 lakhs a bit higher amount, but in same time, maybe higher, but it don't need to deposit. But only condition we want that the petitioner or the accused should appear there at procurement of the attendance. Is the main purpose.
Yes.
So that is and number 2, another one security shall be permanent resident so and so, and own his house or whatever. So in that case, what is your difficulty?
Your Lordship,
Item number, this condition number 2.
Your Lordship, this is the first time this is listed, and if notice may be issued.
Okay,
Yeah.
okay then. Okay. No, otherwise I'm just asking you. Notice means what? Government side is there, I think. Okay, you are Mr.
Elias Laram Chona.
Heard Mr. So the landed counsel for the petitioner. So you are going to appear here?
Yes, my lord, I'll be appearing.
Also heard MS Linda, the learned public prosecutor, State of Mizoram, Assam, also State of Mizoram. This is an application to file under section 528 BNSS, read with section 483 BNSS, to relax or modify the bail conditions imposed by the learned judge special court, learned special judge and DPS in SGPS Aizawl by its order dated 15/9/2025 in bail application number 343/2025. Issue notice to the respondent. However, no formal notice is required to be served on the respondent, as the learned public prosecutor has already entered into evidence. However, copy of the petition be served to the respondent, state respondent, during the course of the day. Here you need is it there in necessity to call for the record?
I don't think so, my lord.
I don't think so.
I'll
Yes.
just take instructions in that regard.
Yes. Let the matter be occurred. How many weeks you need? 1 week?
Your Lordship,
One week.
One.
Your Lordship, if it can be listed on tomorrow,
No. Tomorrow, I have some also personal problem.
maybe
But,
next week.
maybe on next, you want any fixed date here? You want any fixed date here?
Yes, my lord.
Get your priority.
On
When it can be listed?
3rd of February.
3rd
Of February,
of February?
yes.
Okay. We're listing it on 3rd of February. A list on 3rd of February, enabling the state respondent, public prosecutor to take necessary instructions in that regard. Okay.
Much obliged.
For admission, item number 2.
My lord, in this matter, yesterday we have filed one IA for implement of the new officials, my lord. So if the matter may be taken up along with the IA, my lord.
Yes, the implement petition as per the office note dated 28/1, you have not filed.
Yesterday we have filed.
When have I? Yesterday?
Yes, my lord. So the IA could not be
That
listed.
implement the new income,
Yes,
I
yes.
mean the party will be the respondent number 7 or what?
8, 9, 10, my lord.
8, 9, 10.
Yes, three officials are new incumbent, my lord.
Acha.
But the copy is not served upon us.
We have my lord, we have written undertaking, my lord, in the IA.
As on date, it has not been served to us.
Since we did not serve any copy, we are written undertaking, my lord. We have written undertaking in the IA, my lord.
What kind of undertaking? You want to go into submit the undertaking means?
In the IA, my lord. For
What undertaking?
Yes.
What undertaking? What kind of undertaking?
For service of notice, my lord. In the
Service
IA.
of notice.
Yes. The new incumbent will be.
I has already come here? No. It's not
Not
there.
yet.
No, let them supply, my lord.
No,
So copy
IA
to
is
be-
not required, my
counsel
lord.
for the counsel for the other respondent is asking for, you have supplied the copy to the other side, respondent
No,
side,
no.
no, not yet.
Here the main practice is, my lord, in the IA, whenever there is any implement, we do not serve any copy to the respondents. We only serve the main, once they are impleted, we used to serve in the main.
Oh, you are
email
going to
content.
represent whom? Mr. Gupta, you are going
Not
to
I am
represent?
representing railways, my lord. All the railway respondents I will represent, my lord.
You are representing.
Yes, yes.
The IA number is, my lord, 4 of 2026.
So you are representing 1 to 7, all the respondents.
My lord.
Okay. Now you are going to new incumbent officers are 8, 9 and 10. You're going
After
to
implement, my lord, after implement.
That's what I am saying.
Yes.
You are going to implement 8, 9 and 10.
Yes, yes.
You are Mr.
H. Zaudin Sama.
Heard Mr. H. Jincha Soma, the learned counsel for the petitioner, and also heard Mr. H. Gupta, the learned counsel, appearing for the respondent number 1 to 7. It is submitted by Mr. So-and-so, the learned counsel for the petitioner, that yesterday they have filed the interlocutory application for implement of the new incumbent officers as respondent number 8, 9 and 10. Registry is accordingly directed to tag the said interlocutory application with the case record on or before the next date of listing. Next para, Mr. Gupta, the learned counsel for the respondent also submitted they have not received any copy of the petition till date. In that case, the learned counsel for the petitioner submitted that they are going to submit the copy after implement of new incumbent as respondent number 8, 9 and 10. Please, matter how many weeks you need here?
My lord, the matter may be, if the matter may be listed along with the IA, this content may be listed.
It will be listed along with I only.
Tomorrow, if it's
No,
possible,
no,
tomorrow.
we are not going to list tomorrow.
IA is already ready, my lord. 3rd of February, my lord, if
3rd
possible.
of February, many matters have been fixed, I think. No? It can be? 3rd of February will be okay, Mr. Gupta?
My lord, my lord.
Okay.
My lord.
3rd of February, so and so.
Not so
We have already made the direction is already with the registry to tag your
Yes.
IA with the case record.
Yes, my lord. Much obliged.
Obliged.
Oh.
Item number 3.
May it please your lordship? My lord, I have received information that similar matter is filed before the Honorable Supreme Court, my lord, for an appeal. If the matter may be taken up after 2 weeks, so that I can clarify whether the matter is the similar case or not. And if then I can provide the number, the case number itself.
Otherwise, what is the stage of this case here?
The submission
You have
of,
already filed your written, affidavit in opposition there are altogether 4 respondents. All the respondents have filed their affidavit? You are
Not yet.
representing whom?
Well, Lord, I'm appearing for respondent number 3.
You are appearing for respondent number 3. And 1, 2 and 4. 1, 2 and 4.
Chief.
5 and 6 are also there, no?
my lord, 5 and 6 have been removed via the order dated 14/1/2025, my lord. So we have also filed a fresh cost title.
No, you have already filed your amended cost title?
Yes, my lord.
But what about your notices? Have you issued notice to the 5, 6 and 7?
My lord, respondent number 5, 6 and 7 have been struck off, my lord, by this honorable court in order dated 14/1/2002.
Okay, it's strike off?
Yes, my lord.
Okay, okay. Now only 4 respondents are here.
Yes, only 3 respondents.
No, 4 respondents.
4, my lord, yes,
Acha.
4.
But 1 and 2, they have not entered into appearance, I think. Hard MSB Lalunpui, the learned counsel, Valentina given, the learned counsel for the petitioner, and also Hard MS Swenso, the learned counsel appearing for the respondent. From the order dated 18/11/2025, it is seen that the service is already completed on respondent number 1 and 2, but they are not represented by anyone till date. Further, the respondent names of the respondent number 5, 6 and 7 has already been struck off from the cost title of the memo of the present petition. Cost title of the petition. MS Swenso, the learned counsel for the petitioner, submitted in this regard that as per her instructions, one matter is pending before the Honorable Supreme Court, and accordingly she submitted that she needs some more time to take instructions in that regard. Further, you have not filed your affidavit, no?
No, my lord, we have not
Further,
filed.
MS Swenso also paid some more time to file their affidavit in opposition. Post-op. How many weeks you need in that case? 2 weeks?
If I may be allowed to have matter may be fixed after 2 weeks, my lord.
After 2 weeks?
Yes, my lord.
List the matter accordingly after 2 weeks, enabling the respondent number 3 to file their affidavit in opposition, and in the same time, the petitioner will also seek necessary instructions in that regard. List accordingly. Okay, we are listing after 2 weeks.
Yes, my lord. Oblige.
Item number 4.
May it please your lordship.
Yes.
My lord, I'm appearing on behalf of Mr. Lelchan Lianakyangte, and he's unable to assist this court today due to unavoidable circumstances. That is, he's getting married today. So if the matter may be...
For whom you are appealing?
Lelchan Lianakyangte, counsel for the contempt petitioner.
Acha. Oh, he is getting married today.
Yes, my lord.
Okay.
His learned friend and all his juniors are very excited and happy for him.
So you are not going to attend marriage?
I will be attending. It is at 1:30 p.m.
Oh, okay. So who are for the respondents?
Your Lordship, I will be filing Vakalat Nama for respondent number 6 on behalf of Miss Mariel Kyangte.
Respondent number?
6. Siaha DC.
You're going to file Vakalatnama for the respondent number 6?
Yes, Your Lordship.
Okay. And you are representing?
I have filed my power on behalf of respondent number 2.
Respondent number 2.
1, 2.
And my lord, if the matter may be listed on 13th of February, since an analogous case has already been fixed on that date.
13th?
Yes, 13th of February.
Your service is still awaited for the respondent number 4, 6 and 7. 3 and 5 has already been most probably served.
Yes, my lord.
But they are not represented by anyone.
Yes, my lord.
And 1, you are also appealing for 1? No.
Yes, my lord.
1 and 2.
But I have not filed my power yet.
But you are going to appear for 1 also?
Yes, my lord.
Okay. Heard MS so-and-so, the learned counsel appearing for Mr. Lelchan Lianakyangte, the learned engaged counsel for the petitioner, and submitted that he could not assist the court today as his marriage ceremony is fixed today. Further, Mr. So-and-so appearing on behalf of Mr. So-and-so for the respondent submitted that. You have already filed your Vakalatnama or no?
No, we'll be filing today.
That will be filing the Vakalatnama for the respondent number 6 today. MS so-and-so also submitted that she needs some more time to file affidavit in opposition for the respondent number 2, and also needs some time to file the power for the respondent number 1. Full stop. The office note dated 28/01/2026 reveals that the respondent number 3 and 5 remain unrepresented, though the service is already completed on them. Further, the service is still awaited for the respondent number 4, 6 and 7. Full stop. Let the services be awaited till next date of listing. List the matter accordingly on 13th?
13th of February, yes.
13th of February. Yes.
Oblige, my lord.
Item number 5.
My lord, this matter can be taken up for disposal, my lord. So, my lord, if this matter may come up next week on Tuesday, my lord, for hearing at the admission stage itself, my lord.
Matter may be disposed of at the admission stage
Admission
itself.
stage itself, because, my lord, there is some urgency in this matter, my lord.
Okay. Okay then?
No,
Next
no,
Tuesday? Yes, anything to submit? You want to submit anything?
No objection, my lord.
No objection, okay. With the consent of the request made by learned counsel for both sides, let the matter be listed. Next Tuesday is which count? 5th. No, next Tuesday is not 5th.
No, third, sorry.
But
Third,
better to fix on 5th, I think, na? 5th.
Some cases are.
let it be not on Tuesday, let it be on Thursday, that is on 5th.
Certainly, my lord.
List a matter accordingly on 5th of September, 5th of February, so it's
At the admission stage, my lord.
at the admission stage. Okay.
Deeply obliged, my lord.
Item number 6.
Pleadings are complete, Lordship. He may be listed for hearing, Lordship.
They have filed a affidavit, Lordship,
Yeah, I have filed my
recently, and
affidavit.
Lordship, the matter can be listed for an admission hearing after 2 weeks, Lordship.
No, you have filed your affidavit.
They have filed a
have filed.
affidavit. We have filed a revision petition, and they have filed a counter affidavit,
It's a criminal revision.
criminal revision.
So counter, you have already filed or
Yeah,
not?
they have
Already filed, my Lord. I have already filed and now pleadings are complete, Lordship.
Pleadings have been completed.
So it may be listed for hearing.
Can it be listed for any, again, admission stage or what?
Here,
Since the matter has not been admitted yet, so the matter can be listed for admission hearing, Lordship, in the next
that
court.
can also be done.
You are additional PP or
No, madam. I'm the private respondent number 2.
private respondent number 2?
Number 2.
Acha, formal party. Anyway, okay. Heard Ms. Mary, the learned counsel for the petitioner. Also heard Ms. Linda, the learned PP, appearing for the state respondent number 1, and Mr. C. So-and-so, the learned counsel, appearing for the respondent number 2. It is submitted by the counsel for the respondent number 2 that they have already filed their counter affidavit, and accordingly matter will be listed for admission hearing, and which may be disposed of accordingly on the admission stage itself. Considering the submission made by learned counsel for both sides, let the matter be listed. You want any fixed date here or next week any date?
12th February. February
Pardon?
12th.
12th of February. 12th, in admission hearing column. They are
Obliged.
listing it on admission hearing column.
Admission,
itself.
yeah.
Obliged.
For hearing of-
Item number 7.
Lordship, I'm appearing on behalf of respondent number 1. May I seek another 2 weeks' time for filing show cause reply?
So you are going to represent respondent number?
Yes, my lord. Respondent
One.
number 1.
1. Here now see in the other day most probably there was a direction to the registry for track consignment
Yes.
report for,
Yes, my lord.
but they could not track it because of tracking IDs are printed have not been received.
Yes, my lord.
So the registry could not track it. One thing, and then respondent number 4, it has already been returned with a report that address moved to RTS.
Yes, yes, my lord.
And then 3 is still awaited. So 1 she is appearing. So now remaining 2 and 5. 3 is awaited, 2 and 5 is also awaited. What about?
Number for respondent number 4, if I may be allowed to take a fresh steps for service of notice.
It can be taken.
Yes.
But for respondent number 2 and 5, what about? Because the order of tracking of consignment report was there, but most probably
Yes,
they
my
could not, registry could not track it. So can it be awaited, or in that case also you want to take fresh steps?
My Lord, if I
Because
may
now
be allowed
we
to
are-
take fresh steps as well.
Better to take
Yes.
first step,
Yes,
because as it could not be tracked out, so
Yes,
better
yes.
to take, okay. Heard MS Swainso, the learned counsel for the petition. Also heard MS Swainso, the learned counsel appearing for the respondent number 1 and submitted that they need some more time to file their show cause reply. Full stop. Next para, from the office note dated 28/01/2026, it is seen that the registry could not track the consignment report of for the respondent number 2, 4 and 5. However, it is further reported that service report on the notice on the respondent number 4 returned unserved with a note in inquiry command addressee moved to RTS. Considering the note of the office note, the petitioner is hereby directed to take fresh steps on the respondent number 2, 4 and 5 and service be awaited for the respondent number 3 till next date of listing. List accordingly after 2 weeks as on a date to be fixed by the registry, enabling the respondent number 1 also to file their show cause reply.
My
Really
Lord,
state-
if I may make one more prayer, if I am
Yes.
allowed to take back the returned copy of the petition, so I'll take another fresh steps. The returned copy of the contempt petition, if I may be allowed to take back from the registry.
Now others, so I cannot say from the
Yes.
4 you can return.
Yes.
If
yes,
for 4 you can take it return back, but 2 and 5 it is not yet returned, so may not be possible. So you can talk to the registry, and 4 you can take it returned back.
Obliged.
Item number 8.
Mr. Mayor, please, Your Lordship. Service is not completed in this. Service is not completed only in respect of respondent number 2, and 1, 3, and 4 has not yet returned. So, if I may be allowed to take fresh.
You just take, I think better to take fresh step,
Yes.
because from the office note also and from the record it reveals that that notice steps was taken on in the month of October.
October.
So you are appealing for 2.
No, Your Lordship.
Huh?
We will be.
You are appealing for whom?
On behalf of Mrs. Mariel Kiengte, we will be filing Vakal number.
No,
today.
for whom? For which respondent?
Respondent number 6, Shihadisi.
Respondent number?
6, Shihadisi.
6.
No.
4.
Huh? 4?
Yes.
4 or 6? 6.
4, Shihadisi.
Most probably 4 only. Activity. Sorry,
Yes,
there are 4 respondents, so you are appealing for 4.
Yes, Your Lordship.
So he is appealing for 4. Now remains 1, 2 and 3.
1, 2, and 2 has completed.
2 completed.
Completed. And, however, Your Lordship, if I may be allowed to submit this, 2 has completed, but the incumbent is already posted out. The new incumbent is already there. And I have to implement it. I have to implement the new incumbent. However, the new incumbent is also about to leave his post sooner.
Acha. Okay. You are Mr.
K. Roland.
Heard Mr. K. Roland, the learned counsel for the petitioner. Also heard Mr. So-and-so appearing on behalf of MS so-and-so for the respondent number 4. Post from the office note dated 28/01/2025. It is seen that the service is still awaited for the respondent number 1 and 3. However, it is submitted. However, the steps on the respondent number 2 has already been completed. Mr. Swain Roland, the learned counsel for the petitioner, further submitted that the new incumbent has already joined in the place of respondent number 2, and hence there will be requirement for implement of the new incumbent as a respondent number 5. It gives the respondent number 5.
Your Lordship, may I seek your indulgence? We will be filing our Vakalat number for respondent number 3 also.
Oh, for 3 also?
Yes.
Oh, acha, acha. Okay then. 3 kind of did you, huh? Both 3 and 4. That means you are representing for 3 and 4.
Yes, Your Lordship.
3 and 4. Okay, 3 and 4 will do. Take Khali Thakil 1. And then again 2 is already completed. 1 remains. 1 remains, huh? Full stop, so and so. Key dilo last row line. Requirement for next para, in view of above, the petitioner is hereby directed to take necessary steps for implement of the new incumbent as respond number 5, and also he is also hereby asked to take fresh steps on the respond number 1. So 2, 3 and 4 is already over, so 1 only left. So for 1 you can take steps, and for implement of the respond number 5, new incumbent, you can take steps. After 2 weeks we'll do?
3 weeks?
3 weeks. List accordingly after 3 weeks.
Much obliged.
Item number 9.
May I please, Your Lordship. My Lord, in this case, as per a record, service of notice in respect of sole respondent is returned unserved, as the said sole respondent or addressee cannot be found. Address of the sole respondent is written in the petition page number 2. This is the permanent address of the sole respondent. But he is not found in his permanent address, Ramdas, Amritsar district, Punjab.
This is filed by the CBI?
My Lord.
Okay.
A respondent is found to have involved in connection with misappropriation of 747 lakhs from Mizoram Rural Bank.
Okay.
For issuing of fictitious loan. He is one of the accused persons in that case, and the case is pending in the trial court, and is at the stage of evidence. 5 or 6 witnesses were examined so far.
So what was the order of 10/9/2025 against which you have come before this court? Na?
My Lord,
where is the order?
Page number 21.
21.
Yeah, annexer, sole annexer. Last para. Last para further, the court did not receive the present address or whereabouts of accused number 1 Mangatram Kudandal Sasi alias Atif Ali from case IO, and in the previous court order dated 16/7/2025, it was reported that the case IO submit acknowledgement letter showing that they cannot trace the whereabouts or address of A11. Therefore, the court feels that it is not possible to proceed against him without producing the accused before court or without knowing the address itself. Thus, without accused or his address for proceeding, the court consider there is no sufficient ground to proceed the case against him. Hence, A1 so and so is discharged as per section so and so.
Why he is discharged?
Discharged. So, in place of discharge, he should have been declared or proclaimed as offender. Thereafter, the case will be proceeded in his absence. But without doing this, the said accused was simply discharged, opening it may open floodgate for other accused who managed to escape trial hereinafter. For which reason this case is filed for proclamation of the sole respondent herein, instead of simply discharging him.
now, obviously, there could have been any order of declaring him as a proclaimed offender, or the standing warrant could have been issued against him.
Yes.
So that as and when he comes, or it can be a warrant can be executed, the case will be proceeded.
Yes.
But discharge, I think that should not be.
Yes.
But
Without
now
discharging, in
now
warrant
the
of
question is
arrest.
that once the case is, the order of discharge is there against the present petitioner, I
Yes.
mean the respondent.
Yes.
So in his absence again, the order is
Yes.
should not be passed. So now what is your option? How will you, is there any way to procure his present address, permanent address? Is there any possibility on your part? In
No.
that case, otherwise, because now he got discharged from this case.
Since there
So-
is no hope for his location by the enforcement agency.
So you are the
It may
CBI
be-
agency, so there may be some sources, or from the other accused person. He is most probably A11. So obviously there are some other accused person, maybe 10, 12 or whatever.
My lord.
Now from them, can you get any clue, anything
No.
about his residence or about his permanent address?
His
Otherwise-
non-residency, so whatever is written in the petition. So except that one, it is not known his residence throughout the territory of India. So
No, I'm not on that. The other accused persons who are still appearing before the learned trial court below, from them whether there is any possibility to procure the present address of the accused petitioner.
No.
Otherwise, how will you get the address?
Other-
And we cannot pass any order in his absence also, because it is a case of discharge.
Yes.
It's not a case of the other ways, it is a case of discharge, so we have to hear the other one, the accused one. But
Other-
obviously, it is not a case that on merit, it was, the order of discharge was passed. Only simple observation was there in the court, where I also agree with you that there should not be any order of discharge at this stage. There are many ways for thing. So, but now, if the person is already been discharged, so we need his address so that it can be otherwise. See
Oth-
what can be done otherwise.
other persons are local persons herein. So none
There,
of them.
other persons are local persons.
Yes.
From here.
Yes. He is the only outsider. He means the sole respondent. So,
So, but at the time of the inquiry of the case, by your investigating agency, there may be some, I don't know, I cannot say at this stage, but his presence or his notice, at least notice has to go. Think of it, try to get if any source is there. Otherwise, what to say, because order of discharge is there.
yes.
That is the case.
The learned trial court has to issue warrant of arrest 2 times before other step is taken by him. So, but without doing that one, he simply discharged that the
Instead
said
of
accused.
discharging him, his order case against him could have been filed also. As and when the accused person is, suppose warrant is executable, then in that case, again, it can be reopened. But discharge should not be there.
Yes, and the said
Discharge is,
discharge will
otherwise, yes.
open floodgate to other
So you
accused
try it
persons.
somehow. Let's see if you have any sources, because you are the agency, investigating agency as a CBI, may have some sources. Just try it. What to say
Yes,
otherwise.
we'll try.
Heard Mr. Your special PP, na?
Yes, a special PP.
Heard Mr. Lal M. Thenga, the learned special PP for the petition. First stop from the service, from the office note. It is seen that the case, the notice could not be served to the sole respondent, and it returned unserved with a note that addressee cannot be located. Addressee cannot be located. Inverted comma without the addressee cannot be located. Put it inverted comma. Mr. So and so, the special PP submitted in this regard that That was the only address with the investigating agency at the time of the inquiry, and who is a resident of Amritsar, Punjab. In view of this, the petitioner is hereby asked to procure the permanent and present address of the accused petitioner if any available sources is there. And if the present address can be procured, the steps may be taken in the present address, present and the permanent address of the respondent, sole respondent. List the matter accordingly. 2 weeks, I am giving just
My lord.
after 2 weeks. After 2 weeks, as on a date to be fixed by the registry. Okay, try
That's
this.
okay. Item number 10.
Lordship, I'm appearing on behalf of correspondent number 1. May I seek another 2 weeks' time for filing affidavit in opposition?
Respondent number 4 has already filed, I think, no?
Yes, sir. We have already filed.
You have already filed.
My Lord, appearing for the petitioner on behalf of my senior, I pray that let a notice be reissued against the defendant, no, the respondent number 5, that is additional DC Kala, and allow us to take fresh steps for service of notice by registered post with EDI.
For respondent number?
No, ma'am, petitioner. The petitioner.
No,
for the,
you are for the petitioner.
Oh, the respondent number 5, additional DC.
Respondent number 5. Respondent number 5. 3 also filed his 3. You have also filed your affidavit. You are representing 3. You have already filed, na? 3 had already filed. 4 you have filed.
Yes,
You are for 1.
Yes, my lord.
You are for 1. And National Highway Authority is who is appearing? Is the standing council are there, I think, for National Highway Authority?
Your Lordship, I am appearing on behalf of my senior, who is standing counsel for respondent 2 and 3. My senior is on legs on the other court, my lord.
2 and 3? Both 2 and 3?
Both 2 and 3.
Acha, both 2 and 3. No, I have found here, that means affidavit in opposition filed by 2 and 3 already. Okay. Okay, 4 is also here. You are MS?
Gina Vanashwayi.
Hard MS Jia Valaswamy, the counsel appearing on behalf of whom?
PC Lal Thangmoya.
PC
Lal Thangmoya.
Lal Thangmoya for the petitioner. And also heard MS, you are additional AG here?
Yes, Your Lordship.
Additional AG, MS so-and-so for the respondent number 4. And
I'm
Mr.
sorry, Your Lordship, I'm government advocate.
Oh, sorry, government advocate for the respondent number 4. And Mr. You are Mr.? Hello? You are Mr.?
Mr. Philip Vamal Soma.
Is Pamela Soma, the counsel, appearing for respondent. You are for appearing for Mr. Samuel, no? Appearing for Mr. Samuel Banerjee for the respondent number 2 and 3. MS so-and-so, the learned counsel for the appearing also for the respondent number 1. Respondent number 1. And it is submitted by her that they will be filing their affidavit in opposition and need some more time for the same. Further, from of record, it is seen that the respondent number 2, 3 and 4 have already filed their affidavit in opposition. And it is submitted by MS so-and-so, the learned counsel for the petitioner, that they are going to take fresh steps for the respondent number 5. Issue notice accordingly through speed post and as usual process for the respondent number 5. List the matter accordingly after 3 weeks, enabling the respondent number 1 to file their affidavit in opposition as well as service be awaited till next date of listing for respondent number 5. list accordingly. We're listing it after 3 weeks. Within 3 weeks, you also file your affidavit in opposition, and we will be awaiting service for the respondent number 5. You take stage for the respondent number 5.
Much obliged.
Item number 11.
May it please your lordship. My lord, this regular first appeal is presented against the impugned judgment and order passed in Civil Suit 23 of 2017. I am the appellant. I, being the appellant, is the respondent in the trial court, defendant in the trial court, and the present respondents are the ones, the plaintiff, who filed the suit. And by this judgment and order, it was illegally directed by the learned trial court that the land and the building thereon, which is registered in my name in accordance with law, was partly distributed to the respondents. The respondents didn't even challenge the mutation of the landed property, the land settlement certificate, in my name, which was put in my name, after the purchase was made in my name from the previous owner. But despite that, the learned trial court said that some monies had been contributed for purchasing the money, so it has to be partly distributed in favor of the respondents. But
the respondents also some money. You took some money from the respondents.
No,
also?
no, my lord. But it was the case is like this. I had a previous wife who unfortunately died, and my previous wife had the children who are the respondents, and they were born from the previous marriage. I'm talking about my previous wife. She had the previous husband before my marriage with her, and the respondents were born from their wedlock. And unfortunately, the previous husband died, and thereafter my previous wife also died. And the respondents and I were staying together in that house. And during the subsistence of my marriage with my previous wife, who is the mother of the present respondents, and we in the sense that I purchased the landed property, which is the subject matter of the suit. And since it was purchased during the subsistence of my marriage with the respondent's mother, after she died, they claimed that I thought of selling the landed property because it was in my name. Till now it is in my name. And I asked them nicely that we will sell this, you also leave the landed property. And due to that reason, they filed a suit, claiming that our mother, from her savings, she also contributed some amount. And that was why they filed the civil suit. And even without, they could not prove, even in the evidence, that the savings were also contributed for purchasing the money, because sale deed was executed in my favor, in my name only, with the previous owner. Plus, it was mutated, the land settlement certificate was also mutated in my name.
So what was their claim in the title suit?
My lord?
What was the claim of the respondents in the title suit?
Yes, in the title suit, they say that we have to get the possession in the landed property.
So they are claiming for both right, title, interest and possession.
Yes, without challenging the putting of the LSC in my name, land settlement certificate. Because Section 22 of the Mizoram Land Revenue Act 2013 says, my lord, that whoever is the holder of the land settlement, he has the absolute title, owner, transferable right, all the rights.
So now what is the order of the learned trial court?
Learned trial court says that without quashing the registration of LSC in my name, the learned trial court simply distributed some floors to the respondents. That is incorrect. That is illegal.
She distributed some property.
Yes, the subject matter of the property, my lord. And even before the trial court, they clearly admitted that they didn't challenge the mutation of the LSC also. So notice kindly may be issued, my lord. And appeal may kindly be admitted.
So two respondents are here.
Two respondents only.
You are Mr.
Bilal Ramenga.
Mr. Bilal Ramenga, the learned counsel for the appellant. This is an appeal. Filed under section 96 CPC, read with section 17, subsection 2, subsection small b of Mizoram Civil Code Act 2005 against the impugned judgment and order dated 30/10/2025 and the decree dated 30/10/2025 passed by Learned Civil Judge Senior Division number 4 Aizawl, Mizoram in civil suit number 23/2017, whereby the decree granted partly in favor of the whereby the respondents were also provided some floors of the building which is in the name of the present appellant and which is also standing over the land which is purchased by the appellant. Further, it is submitted by Mr. Langrema that the land is, the settlement is still in favor of the appellant. Poster. Considering the submission made by Learned Counsel for the appellant, appeal is admitted. Issue notice to the respondents through speed post and as usual process, and also call for the TCR. List the matter accordingly after 3 weeks will do?
Yes, ma'am.
After 3 weeks as an date to be fixed by the registry. Okay, you text it?
Yes, I'll text them, madam. Much obliged.
For orders, item number 12.
May please, Your Lordship, my Lord. My Lord, on the last court date, trial court record has been called. On the last court date, trial court record has been called, my Lord. This is a bail application
Trial
filed.
court record we have now? We have received the trial
Yes,
court record
yes,
now?
my Lord.
Okay.
My Lord, this is a bail application under 483 of the BNSS 2023. Basically, my ground for bail is there is no ground of arrest.
No?
No ground of arrest, my Lord.
Achha,
Violation
grounds
of
of
47, my
arrest.
Lord.
Okay. Have you annexed your arrest memo or the notices under section 47?
Yes, my Lord. It's in page number 35, my Lord.
Page number?
35 of my bail application, my Lord.
35.
Here, my Lord, there are 6 accused in this case, my Lord, and I'm accused number 2. And in page number 35, my Lord, there are only 4 accused given wherein ground of arrest were intimated, my Lord. My name was not included, my Lord.
Your name?
My name was not included in the ground of arrest, my Lord. I am not intimated, my Lord.
1, 2, 3, 4. You are not this person.
Yes, my Lord. My Lord, if I may take my Lord to page number 30 of the bail application, their name of accused are clearly given in the charge sheet, my Lord. Page number 30 of the bail application.
So what is the stage of the case at present? It is charge sheeted one?
Charge sheet has been filed and 1 evidence has been recorded, PW1, my Lord.
So how you got arrested in here in this case?
Allegation is that I...
No, allegation is okay. Now you are saying that your name is not there in the page 35.
Yes.
In the arrest memo or
Yes, my
the
Lord.
notices. So then subsequently you got arrested in this case or what?
I was arrested on the same date, my Lord, 3rd June 2015. Same date where the other 5 accused were arrested, but intimation of ground of arrest was not given to me, my Lord.
3rd June 2025 you got arrested.
Yes, my Lord.
Ah.
And on the same date, ground of arrest were given to 4 accused out of 6. That is in page number 35 of my bail application, my Lord. And that my submission is that I was not intimated the ground of arrest, my lord. And there's a violation of Article 21 and 22 of the Constitution of India, my lord.
So what do you want to show from 30, page 30?
30 name of accused are given, my lord. I am accused number 2, my lord.
You are the accused number 2?
Yes, my lord. Her name is Lalrin Chani, my lord.
Uh-huh.
And in page number 35, the applicant is not intimated, my lord. Only 4 out of 6 were intimated ground of arrest, my lord. Do I need to submit judgment, my lord, to support? I think it's quite clear, my lord. Once ground of arrest is not intimated, accused is has right to be released on bail, my lord.
The arrest memo was there, or arrest memo was also? Because you are showing the 47 notice. It is
Yes.
the 47 notice, but where is the arrest memo? Have you annexed it or not?
I don't file along with the bail application, my lord. My lord, I even perused the trial court record, but I was not intimated, my lord. Ground of arrest was not intimated.
But you are saying that you got arrested on 3rd of June 2025 along with the other accused person on the same day.
Yes, yes, my lord.
And till now, one witness is examined.
Yes, my lord.
As a whole, how many witnesses are there, cited witnesses?
My lord, 7 total.
It's a case of commercial quantity?
Yes, my lord. Though I pleaded other various grounds, but my main ground is that I am not intimated ground of arrest, my lord.
Yes, Your Lordship. It is fairly submitted that separate grounds of arrest in writing was not reduced to the present appellant. However, Your Lordship, as per the report of Caesar and arrest memo, that is in page number 17 of the bail application. One seven.
Yes. What is it?
If I may read out, Your Lordship. Subject report of seizure and arrest. Sir, I have to report that on 3rd June 2025 at 7 a.m. I received an information stating that 2 ladies from Kolasip New Yakon named Mabiaki and Matsani are suspected for possessing methamphetamine in their residence. I then with my duty team proceeded to take necessary action. At first at the residence of Mabiaki at Lalbiakluni, daughter of Laldin Thara of New Yakon, Chalui Veng Kolasip, along with her companion Matsani at Lalrin Chani. This is the present petitioner, Your Lordship, Lalrin Chani. Of New Yakon CP Road, Kolasip at 8:20 a.m. I arrested them as they confessed that they possess methamphetamine and handed over to Roya of Truampui Veng, Kolasip. After arresting them, we proceeded to the residence of Roya at Truampui Veng. And Your Lordship, in the last para, in page 18, During seizure and arrest, recording was done under Section 105 of BNSS 2023, where I also mentioned the hash report as on the seizure and arrest memo. Intimation of their arrests were given by a phone as well as on the spot in their residence who were present. So, Your Lordship, it can be seen that arrest intimation was given them orally, but not in writing.
Now see, sometimes it happens that notices were issued, but the detail of or detail or specific information about the cases may not be there. But here you see the action of the investigating officer. In one notice under 47, they have named 4 accused persons.
I understand.
Is it permissible? You cannot. And that apart,
Exactly.
there is nothing is there that the 48 was issued to them, these family members or anyone. And particularly for the present accused persons, it is not at all there.
I understand.
Do you have you gone through your record? Is there any? I have
No,
not.
Your Lordship. I
No.
already submitted fairly that there is not. No written.
Say, but there are many matters which were dealt with this particularly this aspect in the principal seat also and many states also. After the Bihan Kumar and the Prabir Purkayastha, there are many matters come up where the police officer, but now in the many states these are doing. But here too, he got arrested in 2025, wherein yesterday only or day before yesterday, I was shown one notification from the state of Mizoram where the police authority was directly asked or directed to this notice in writing, or the even 36 is also here to ask to comply with. But in spite of that, how negligently is they are doing? See the fun. This is a big case of commercial quantity. The methamphetamine tablets were seized in a huge quantity. That's why it is a case of commercial quantity.
Exactly.
Used racketeering may also be involved. But why this kind of thing is there?
My Lord, in this
Very
case,
surprising.
in this case, even in the trial court, the counsel appearing in the trial court also submitted this Bihan Kumar judgment, and the judgment rendered by you in different case, my Lord. Though that has not been considered, my Lord.
Where is the rejection order here?
It's there in the report, my Lord.
No, have you filed your rejection order also? No.
Yes, it's in
page
number 26. It starts from page number 26, my Lord. And the
26.
relevant part is in page number 28, my Lord. May I read, my Lord?
Now, basically, 37 is straight on. Yeah, obviously, 37 is there. We won't deny it that 37 is obviously there, where the twin condition has to be satisfied. But here, the seizure, from the seizure memo or the arrest memo, it reveals that she got arrested directly from her position. Also, some methamphetamine tablets were already been recovered. So that is there. So, okay, then I'll see. As the order.
Obliged.
Obliged, my Lordship.
Item number 13.
Just go and give a dictation in the chamber only.
Lordship, I'm appearing on behalf of my senior Mr. Johnny L. Dauchong, counsel for the appellant in this matter, my Lord. And it seems that, my Lord, the ID card is not returned till today.
What is the IA for? IA is for?
I is for the condonation of delay, my Lord.
Condonation. Have you issued notice in that case?
Yes, my Lord.
In
We
IA,
have taken steps.
how many days delay?
46 days delay, my Lord.
Oh, now this is the bail application. How many days?
46 days.
46 days.
Yes,
Is any
ma'am.
company also here?
Yes,
Oh,
my
you
Lord.
are the Oriental insurance company?
Yes, my Lord, we are
Okay,
the
okay.
insurance company.
So who is the respondent here? Is the owner, driver or claimant? Who is he?
Respondent number 1 is the claimant, my lord. And
1 is the claimant.
Yes, my lord.
2 is the assistant manager.
2 is the owner of the vehicle. And respondent number 3 is the driver of the
Driver.
vehicle.
Okay. No, see, 46 delay is, can be condoned easily, but this is first time most probably it has come, so you have to issue notice. In the other day, you have issued notice?
Yes, my lord. We have
Or it
taken.
is still awaited? Okay. You are Mr.?
Lalmang Isanga. On behalf of my senior.
Heard Mr. Swenso, the learned counsel appearing on behalf of Mr. Johnny L. Tolson, the learned counsel for the applicant appellant. Office note reveals that the service is still awaited for the respondent number 1, 2 and 3. Let the service be awaited till next date of listing. List accordingly after 2 weeks. After 3 weeks as on a date to be fixed by the registry.
Obliged, sir.
Item number 14.
So
My lord.
why is I is for?
This IA 138 is for condoning a delay of 889 days.
How many days?
889, 889.
Oh, 889.
Yes, my lord. And respondent, there are 7 respondents. 1 to 5, as well as respondent number 7 have been represented. But notice is still awaited on respondent number 6.
So
Edicard-
you are representing whom?
Lordship, I am for the respondent number 1 to 5, my lord.
1, 2, 3, 4 and 5.
1 to 5, my lord.
That means 1, 2, 3, 4 and 5.
Yes, my lord.
Okay.
Yes, my lord. And I will be filing written objection, my lord. And 2 weeks' time may be required, my lord. for
6 is
filing-
awaited, you are
6
saying?
is awaited, my lord.
And 7 is the insurance?
7 have already filed.
You have already filed?
Yes, my lord.
In respect of respondent number 6, my lord, if the registry may be directed to track the consignment, my lord, because notice was issued
Now just
way
tell
back
us who
in.
is respondent number 6?
He is the driver of the accident vehicle, my lord. She is a necessary party.
Necessary?
Yes, my lord.
Okay.
Steps was taken in October last year, so if the consignment may be tracked, my lord.
You are Mr.?
Sitlan Thiang Lima. I'm
Pardon,
appearing
sir?
as a legal aid counsel, my lord.
Appearing as a legal aid?
My lord.
Mr. So-and-so, the learned legal aid counsel appearing for the applicant appellant. And also heard. You are Mr.?
R. Lilwood Fella, my lord.
R. Negotium, the learned counsel appearing for the respondent number 1 to 5. And also heard Mr. You are Mr.?
Lalmang Isanga on behalf of my senior.
So-and-so appearing on behalf of Mr. So-and-so for the respondent number 7 of the insurance company. However, from the office note, it is seen that the service is still awaited for the respondent number 6. Though the steps was taken for the respondent number 6 in the month of October 2025. In view of this, the registry is hereby asked to find the track consignment report for the respondent number 6 and to report court accordingly on the next date of listing. List the matter after 2 weeks will
My
do.
lord.
List accordingly after 2 weeks.
My lord, may I interfere? My lord, could you please give me a chance for filing written
Written
objection?
objection?
Yes, yes, my lord.
Next,
Respondent number 1 to 5, my lord.
Mr. So-and-so, the learned counsel appearing for the respondent number 1 to 5 also submitted that he needs some more time to file his written objection. Prayer allowed. Usme बाद में लिखो list after 3 weeks, enabling the respondent number 1 to 5 to file the written objection if any. List accordingly. Okay then.
Obliged.
इसमें hearing है अभी? No hearing? Okay. How many left in fact from this? That
Maybe 2 or 3 only.
2 or 3 only. One will be listed tomorrow, huh?
Yes.
Yeah, I have already dictated yesterday itself, so it will be listed tomorrow. So that- You come to my chamber, huh?